This is a message from the Society for the Prevention of Stupidity to Animals. There is a tragedy going on in major city parks all over this country. Our current inner-city drug problems have created a terrifying phenomenon. Crack-addicted squirrels, yes, innocent, defenseless squirrels, are collecting discarded crack vials instead of nuts, and these poor squirrels have become addicted and will do anything for their next fix. It is not a pretty sight. For your donation, you'll get a picture of your squirrel and a letter detailing his or her daily progress. The sight of roving squirrel gangs is pathetic, attacking chipmunks and pigeons with used syringes, little bandanas on their heads. It's frightening, and something must be done. Won't you help? Help a crack-addicted squirrel get the monkey off its back. Remember, a squirrel is a terrible thing to waste.
Welcome to Facts or Frauds.
This is State of Kansas versus Quentin Lawrence Heidt. It's case number 2025 TR 1215. Quentin Heidt appears apparently on his own Zoom. Jaron Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. For Heidt, court has an information before it which alleges in count one the charge of interference with law enforcement, a Class A non-person misdemeanor punishable by up to $2,500 fine and up to 1 year in the county jail or both. In count two, failure to register a vehicle, an unclassified non-person misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine or both. What are your intentions regarding a plea here this afternoon, Mr. Heidt?
Good afternoon. I do not intend to plead.
Why is that, Mr. Heidt?
I have a few clerical things I'd like to clear up. Did you personally read the case filing for BU-2025-CR-000261 in its entirety?
No.
Do you believe that the filing document is true, complete, and correct?
I'm not sure why I'm answering your questions, Mr. Heidt. We're here on a first appearance on a criminal case.
I am trying to clear up to make sure that the charging documents are true and correct before proceeding.
I see nothing openly defective about the charging document.
Okay,
Well, let's move on. If you don't wish to enter a plea, the court will be entering a plea of not guilty on your behalf, Mr. Heidt. And we'll be establishing another court date.
Your Honor, that would not be my preference. I would like to have...
Well, I don't care if it's your preference or not.
Thank you. I would like to have a probable cause hearing before a plea.
You're not entitled to a probable cause hearing. This is a misdemeanor case rather than a felony case, and you're not in custody.
Okay, I have challenges that I would like to raise on the record formally for both the case filing and the field case report from the arresting officer.
Let me ask you, do you believe that you have the financial resources to hire a lawyer to represent you in this case?
I will not be hiring a lawyer. Thank you for asking.
So you're going to represent yourself in this case, is that correct?
I will be presenting myself. That is correct, yes.
You do understand that if you can't afford a lawyer, the court will consider appointing you one.
I do comprehend this. Thank you.
But you reject either retained or appointed counsel, and you're going to represent yourself in this case, correct?
I will be presenting myself.
Very well.
Thank you.
There was an appearance bond posted in this case. Apparently, it was a cash bond in the amount of $2,000. It secured the defendant's appearance. The court has approved that bond and will maintain Quentin Heidt under it, pending further proceedings in this case, which I will set.
Before that, I would like to request your lawful determination that this court has jurisdiction over this matter, as I cannot proceed until the field case report and the case filing are both verified complaints and true and correct.
I don't know where you're getting all this. According to the state's charging document, I'll advise you, Mr. Heidt, that it did take place somewhere in Butler County, Kansas.
Okay, thank you for
The
that.
court does believe it has jurisdiction.
I do have a copy of a field case report and a case filing that I received from the Butler County Attorney's Office as well as the Butler County Sheriff's Office, and I have found inconsistencies in both of the documents that I'm trying to raise here formally with you that I cannot make a plea until they have been resolved.
All right. So I've entered a not guilty plea on your behalf.
I would like to please the court that this would be not on my behalf and under threat and duress, and only under the matter that you have moved on my behalf. I have not entered a plea.
All right.
Additionally, I'd like to let the record show that due to a lack of corpus delicti via verified complaint, jurisdictional defects, and the lack of essential elements to bring a formal complaint and charges against me, I must move for dismissal immediately based on the plaintiff's failure to present all the required elements. That is in regards to the case filing. Judge, I would also like to ask, will you be reviewing the case filing and field case report in their entirety to ensure that my due process rights are not violated before the arraignment hearing begins?
Court's going to assign the case to this division. I'm going to set a court date for Monday, August 25.
And what is the purpose of that court date, may I ask?
For further proceedings in the case, Mr. Heidt. It'll
Okay.
be your first appearance with following today's date. I'm going to set the hearing time at 3:00 p.m. You may appear by Zoom.
Is there an
3
in-person?
o'clock Monday, August 25 for further proceedings in this case before this court.
Thank you. And may I ask, is there an option for an in-person appearance?
Not for that court appearance.
Okay.
We'll conduct the next appearance by Zoom.
Okay. Is there an opportunity to be in person for any proceedings?
Yes.
Okay. And which proceedings would those be?
But what we've established today is the next one will be by Zoom. Now,
Okay.
if you don't want to appear remotely, you can come to the Butler County Judicial Center and you can participate from that location. You'll be participating by Zoom, but you can participate from the Judicial Center. So make sure that you have the resources available to you to fully participate in the next hearing. So Monday, August 25, 3 o'clock, he's going to represent himself. And the court has approved and maintained him under his previously established bond of $2,000 cash.
May I also ask what judge?
Just a minute, I'm going to ask the prosecutor. Mr. Ricke, is there anything else that we need to address regarding Quentin Heidt at this time?
Not on this particular matter, Your Honor, although per my duty of candor as an officer of the court, I would tell the court that there does appear to be another case involving this same defendant, where it would appear that an appearance bond has been executed for at the end of next month. I'm not sure, given the court's orders, if the court wishes to address that matter at this time for the purposes of the judicial economy.
No. If he has multiple cases, that's the implication of having multiple cases, that he may have multiple court dates.
Very good.
So let's go ahead and cite for Mr. Heidt, just in case he doesn't have it written down on his calendar somewhere. What is the next scheduled appearance in this other case?
Your Honor, the state's information is that in Butler County 25 TR 1215, there appears to be a bond, specifically a cash bond in the amount of $1,000 for an appearance date on July 30th, 2025 at 9 a.m.
All right. I'll advise the defendant that he does have a separate appearance requirement in a different case for July 30th at 9:00 a.m. I trust that would be in Zoom court with Judge Webster on that date, Mr. Ricke?
That would be the state's presumption, Your Honor.
Okay, and then of course you've still got your Zoom appearance requirement in this court on Monday, August 25 at 3 o'clock, Mr. Heidt. I think that concludes our business on the case at this time.
One further question, please. For this matter, the new hearing that you have just set, who is the judge and the court presiding?
The new one that I just said. You mean in this case that was before the court today?
Correct.
This judge is hearing the
Okay.
case. Okay.
Thank you for clarifying.
And if there's nothing further, the Quentin Heidt matter will be in recess at this time, and we'll move on to another matter.
Thank you for your time.
We're on the record in 2025 TR 1215, State of Kansas versus Quentin Lawrence Height. Brett Sweeney for the state. The defendant appears in person and per se. Mr. Height, count one, you're charged with driving without your license and possession when demanded, an unclassified misdemeanor, a sentence up to 30 days and $500 maximum fines. And count two, driving without registration or tag, an unclassified misdemeanor, up to $2,500 in fines and 30 days to 6 months. How do you want to proceed, sir?
Good morning, Your Honor. My name is Quentin Lawrence Height, the accused in this matter. I'd like to briefly state for the record that I have made good faith efforts to meet with the prosecution prior to today's proceedings. I called the Butler County Attorney's Office twice and had in-person meeting times set up to discuss a dismissal agreement with the intention to obtain and present a valid Kansas driver's license, insurance, and registration on the car involved. Unfortunately, I was rescheduled on both occasions. The most recent meeting was scheduled for yesterday afternoon, but I was informed that Jared Regier had jury duty this week. At 7:55 a.m. this morning, I sent an email proposing a dismissal agreement. I also called the office at 8:19 a.m. to speak with Mr. Jared and his team, but unfortunately, Jared and both Brett Sweeney were unavailable. With that said, I am not sure if Mr. Sweeney was made aware of my meeting attempts, emails, or phone calls this morning by the receptionist in the county attorney's office this morning. Additionally, I do have a meeting set in person for August 7th at 3 p.m. for the discussion of the same matter. Given these circumstances, I request a continuance. I believe with a short amount of additional time, we may be able to resolve this matter efficiently without burdening the court. I'm also available to meet with the prosecution in person over the phone after court today or before 1 p.m. tomorrow. I'm also available to register my car on the same timeline to satisfy the diversion agreement. I respectfully ask the court for a brief continuance so that I may pursue this resolution opportunity directly with the county attorney's office. Thank you, Your Honor, and I yield.
All right, so are you waiving your right to counsel then and representing yourself?
I am presenting myself today.
And you understand that you can hire any attorney, and if you cannot afford to hire an attorney, you can apply for court appointed and see if you qualify?
I do comprehend, yes.
Okay. Would you wish to proceed on your own behalf? Is anyone making you give up your right to an attorney?
No one.
All right. Well, I'm showing that you have knowingly and voluntarily waived your right to counsel so you can represent yourself. Put that, please, in the journal entry and docket notes. Next, have you looked online at the diversion program to see if you are interested in that?
I have not had an opportunity to do so. As I had stated, I was hoping to discuss the terms in person with Mr. Regier or hopefully this morning Mr. Sweeney, but they were both unavailable. So at this time, I have not reviewed the terms, no.
Looks like you have some pending cases in about at least 2 other counties. Does that sound right?
I would like to say that those matters are separate. I don't know if that is true or correct.
Well, 2 of them are in Butler County. It looks like one in Sedgwick. Let me see when the court date is so we can maybe put them together.
In Your Honor, I was going to mention that this case has actually already been set on Chief Judge Ricke's docket for another hearing, August 25th at 3 p.m.
May I ask, Destiny, are you talking in regards to the current matter that we were discussing today, the 1215?
Yes, it's regarding this case. It's going to be set with the other case as well, though.
Interesting.
Right.
Okay.
Okay, so Judge Ricke reassigning these 2 cases to himself?
He is, Your Honor.
Okay. Is there a felony case, Mr. Height?
I'm sorry, say again, please.
Well, I was just curious why Judge Ricke would snag 2 misdemeanors out of the group here. Do you have a felony case pending with Judge Ricke?
Not that I'm aware of, and as of my first hearing on the other aforementioned matter, he said he would not be lumping these two together. So this is of news to me. I was not made aware of this. And I also did state that my preference would be to have them separate, and he agreed as such. So this is interesting to me.
Mr. Sweeney, any information you might be able to have or like to shed on this?
Just kind of hearsay, Your Honor. Mr. Ricke, prepping me for today's docket, did talk to me about this case and say that maybe he had a meeting coming up with the defendant, but he did mention that Judge Ricke rather took one of the cases, but my understanding in speaking with Mr. Ricke is that the other case was to remain in front of Your Honor. So all of them are misdemeanors, of course, including this one. But my understanding is that he was retaining one of the misdemeanors, but this traffic case was to remain down here. I could be incorrect, but that's what I understood in speaking with him.
And I believe that was what was previously stated. I do have a note as well on this case in the 25 TR 1215 from Judge Ricke's assistant, stating that it's to be moved and set for August 25th at 3 p.m.
Okay.
All right, Mr. Heidt, I'm not sure what Judge Ricke has in mind, but I trust he does, beyond any doubt. So we're going to move this case to Judge Ricke's docket, August 25th at 2:30.
Okay.
And license and registration. No clue, but I have plenty of cases to object. I'm grateful for any help. Let's see.
I would like to note on the record that it is my preference to keep these separate. Just wanted to make that heard.
That will be noted. Please note that on the record. Two unclassified, you don't have to make bond in that case. So I'm going to order that you reappear at the date and time given before Judge Ricke. Did he say whether he wanted that by Zoom or in person?
My request would be to be in person, and also I did want to state one more further thing for the record that the judge had during, like I had mentioned earlier, but wanted to make sure the record reflected that he was not planning to put them together. So just making that available. Thank you.
Okay. All right. Well, you may go, sir. You're excused from these proceedings. Just make sure you reappear at the date and time given.
Okay, and one more time for me, please. The date.
August 25th at 2:30. Didn't you say, Destiny?
I show at 3 p.m., Your Honor, but
Okay.
August 25th nonetheless.
August 25th, 3 p.m. And did he say again in person, or did he specify Zoom or in person?
I show that the other case is set by Zoom, so I would presume that both will be set by Zoom, Your Honor.
Okay. You might call back close to the date and confirm that that's right, sir.
Okay.
If you want a court-appointed attorney, you need to turn in an application for one. Do you want an attorney?
I do not.
Okay. All right. You may go, sir.
Thank you for your time.
Thank you for yours.
And October 2nd came, Sovereign Heidt failed to appear. So, a warrant was issued with a no bond hold. What did Sovereign Heidt do? Well, he ran from that warrant for a little bit and sent in this. Yeah, the Sovereign stuff, it just isn't gonna work on a warrant. I'm sorry, Mr. Heidt, it's not gonna work while you're in jail. It does make for some good reading, I will give you that. And it helps clean up those messy spills that you may have around the house. Let's get to those attachments, that's right. I want to see who's writing and standing up for you, Mr. Heidt. You can thank Matthew. And Sovereign Sydney, thank her too. And yes, don't forget to thank Caitlin.
within the Butler County District Court entitled State of Kansas versus Quentin Lawrence Heidt. It's case number 2025 TR 1215 and 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin Heidt appears from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset for jury at December 10, 9 o'clock a.m. with a pretrial conference established December 3 at 4 o'clock p.m. That time it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously. The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions, and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Heidt applies, which he would like to do. Also, Mr. Regier did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
All right. As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4 o'clock. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I would want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4 o'clock?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Heidt is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer a in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4 o'clock. The court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to do, Mr. Peterson, specifically?
Yes, Your Honor.
Very well. Court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And I
You
was
may
wondering.
proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Heidt is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Heidt doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover spent the last couple of weeks in a lot of self-reflection and thought about how to handle these types of situations and how to handle this current situation. And he is, like I said, taking steps to rectify this and make sure he's never put himself in this type of position again. I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Heidt the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify, what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases, I think Mr. Heidt is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice, and these, they're misdemeanors. He's aware of, what he's accused with and the very serious nature of interference with law enforcement. And, but he'd like an opportunity to show the court that he can do this without, move forward without being in custody and resolve these matters.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Ricke, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior order should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for the defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
Mr. Ricke, you make some good points and you articulate your position well. However, I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Heidt and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Heidt as to where he will be reciting. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current the Park Road. I do have a question. This is being
All right, Mr. Heidt, let me back up a minute. I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Heidt. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all.
I understand your concern, Mr. Heidt. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right, the second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Heidt's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, at this time, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Heidt. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Heidt?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Heidt, as a condition of bond, of course, to appear at that time, Courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Ricke, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Heidt matter, or both cases, will be in recess at this time, and this meeting may be ended for all.
Hi. Well, that's just about it. So, thanks for watching. And we'll see you again real soon.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think.
Actually, I wish you could see the studio floor right now. There's nowhere more fascinating after a show. Everyone's so busy. Buzz. like bees or white Anglo-Saxon Protestants.
And a huge thank you to all of our Facts or Frauds channel members. If you'd like to become a member, click on the link in the description or click join right next to subscribe.
There's electricians all rolling up their cables. Whoops! Sorry, guys. And there's the sound technicians unplugging all the microphones. Okay if I keep mine on for a minute, Nobby? Stand up.
Now, if you're still hanging out, thank you. I appreciate you all. Why not hit the thumbs up button, make sure you're subscribed, ring the bell, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.
And of course, there's lots of the producers' friends, all excited, waiting to meet the stars and generally getting in everybody's way. Just like our producer. Oh, we don't mind. Oh, and not forgetting the prop guys. They're busy striking the set. That's an interesting little point there. Striking. That's a word we all use in the biz for dismantling the set. Taking it apart, unscrewing things, releasing safety catches, that sort of thing.